everyone. Thank you for joining us for another installment of California Employment News. My name is Jackie Simonovich, and I'm a senior attorney in the firm's Labor and Employment Group, and I'm joined today by my colleague, Chris Horsley. Today, we are going to discuss AB 858, which deals with recall and reinstatement rights for workers who lost their jobs during the COVID-19 pandemic. Before AB 858, through the end of 2025, employers in industries that were affected by the COVID-19 pandemic, like hospitality, service, and travel, had to offer available jobs back to laid-off employees if they were qualified. And an employee is qualified if they were employed for at least 6 months and their separation from active employment occurred on or after March 4th, 2020, due to a reason related to the COVID-19 pandemic. Additionally, employers are prohibited from retaliating against workers who enforce these rights. Now, Chris, can you tell us more about how AB 858 extends these protections?
Sure. AB 858 extends these protections until January 1st, 2027, and clarifies that any violations that occur before the end of 2026 will still be enforceable. Supporters of this bill argue that these protections have helped thousands of hospitality workers return to jobs after the pandemic. However, opponents, including hotel industry groups, caution that the penalties for violations could put additional financial strain on businesses that are still recovering from the pandemic. AB 858 was approved by Governor Newsom on October 3rd, 2025, so these changes are now in effect. Consequently, we will see the true impacts of this bill soon. But that's all for now. You can continue to find our video series and podcasts through the lelawblog.com or on the Weintraub Tobin YouTube channel. Thank you everyone for joining us, and we look forward to reconnecting with you on the next edition of California Employment News.